Today's presenter, Russell Jackman, is a graduate of the McGeorge School of Law, University of Pacific, and was admitted to the State Bar of California in June of 1994. He has been vice chair of the California State Bar's Law Practice Management and Technology Committee and a member since 1996. He works specifically with law offices and attorneys that need to get the most out of their legal technology and creates PowerPoint presentations for opening statements, direct examinations, and closing statements to be used in court, and can work with attorneys directly to filter their documents and images so that they have the most powerful visual presentations possible. He also works with law offices and solo attorneys to upgrade their older systems to new ones, troubleshooting existing setups, and training attorneys and staff on Microsoft programs. He is available for remote access consulting on technology-related issues, so please feel free to contact him at any time.
Hello, my name is Russell Jackman, and today we're talking about the Digital Millennium Copyright Act, the Center for Continuing Education. I myself am an attorney, and I deal a lot in the area of legal technology. So the DMCA gets involved in a number of different things, either with my clients or the things that I'm working with. And so it's an important law to understand and to really dig into and understand the details of it. So I'm going to apologize ahead of time for all the black law screens that I've got here. That's not what I typically do, but I think in this case, it is important to understanding the structure of the Copyright Act. And once you've understood the structure of it, then some of what is discussed in the case law will make a little bit more sense. So that being said, what is the DMCA? Well, the Digital Millennium Copyright Act is an amendment to the copyright laws of the United States, which was enacted in response to the lack of laws that address the nature of technology and how it affects the older copyright. And so it modified, created sections and amended sections in 17 USC 512 and so on and so forth. But what it really does is it criminalizes the production, dissemination of technology, devices, services intended to circumvent the measures known that control access to copyrighted works, known as the Digital Rights Management, or DRM. It also criminalizes the act of circumventing an access control, whether or not there's actual infringement of copyright itself. So this all came from the WIPO copyright treaty, WIPO copyright treaty. It was signed in 1996. So it took what was local copyright laws and made them part of an international effort, because really before the DMCA came into effect, the copyright really seemed to end at the borders, and you would have to file for a separate copyright during in each individual country that you were working with. And so it became a very complex and complicated issue to get all your copyrights in a row, file them in all the different countries, get approval at all the same time, so that your copyright would have the same protection universally. And the idea with the copyright treaty was to get that all put into place. But in doing so, they needed the DMCA to be ratified by the United States and to have these the copyright treaty that was agreed to in '96 to be adapted by the United States and the world. And so so what it basically did was it said that no person shall circumvent a technological measure that effectively controls access to work protected under this title. The prohibition contained in the preceding sentence shall take effect at the end of the 2-year period beginning on the date of the enactment of the chapters. They gave everyone a 2-year head start to protect them to get in compliance with the DMCA, which is why it basically became the Millennium Copyright Act, because when it finally kicked in, it was right about the year 2000. So during that time where they were working on it, they created a 3-year review period where a designated librarian would go and review the length and breadth of the DMCA. And a lot of that had to do with the concept that when copyright law was first made, it sort of stayed in a static state for maybe over 100 years. It's certainly, many decades of inactivity, and the law did not change. And as computer technology moved forwards, the intransigence and the static nature of the copyright system was really holding the United States back in innovation and in being able to police the various copyrights, especially international. So they created this 3-year period of review to help get the Copyright Act to review the material that's part of the Copyright Act, and be able to use that to help to get a better a ruling on how it affects the material that is being subject to copyright. Okay. So the librarian is supposed to every 3 years look at the availability for use of the copyrighted works, the availability for use of works for nonprofit, archival, preservation, and educational purposes, the impact that the prohibition on the circumvention of the technological measures applied to the copyrighted works has on criticism, comment, news reporting, teaching, scholarship, or research. And really, that middle part here, the 3 I's, or number 3 in the middle of this list, that really is sort of the central question of fair use, is the impact that the prohibition on the circumvention of technological measures applied to copyrighted works has on criticism, comment, news reporting, teaching, scholarship, or research. If it affects those areas, you're usually able to claim a fair use exception for you using this copyrighted work. And that's that. But of course, there isn't a blanket rule that says, or a listing of what things do meet these impacts. And so that's where we see a lot of cases hinging on, is really this 3I level here. And then the effect of circumvention of technological measures on the market, the value of the copyrighted works, and such other factors as the librarian considers appropriate, which of course is kind of an escape clause there for some subjectivity on the librarian's part. So they have to give it some justification. It can't just be an emotional reaction to say that the librarian doesn't consider this appropriate and we just move on. So clause 2 talks about that no person shall manufacture, import, offer to the public, provide, or otherwise traffic in any technology, product, service, device, so forth, and that's primary design or produced for the purpose of circumventing a technological measure that effectively controls access to work protected under this title. So in other words, if you make an item or a piece of technology that helps copy things, and that's the sole purpose of it, is to break copy protection, be able to uh, make something that circumvents any kind of protections, that's not legal. And then Clause B says it has only limited commercially significant purpose other than to circumvent technological measure. So a lot of the cracking software, hacking software that allows you to break into a particular device and use that information, copy that information, be able to move it to another device. A lot of people don't realize that, for instance, the iPod, which was the big technology at the time, this altered how the iPod really worked because, and it still affects iTunes today, that they didn't want Sony and the other music um, producers, but mostly Sony, said to Apple they didn't want the iPod to be used as a device for people to copy all their music onto and then take it to another computer and dump the information from the music from one computer to another using the iPod basically as a portable hard drive, which basically, for all intents and purposes, really was. So instead of having the ability to copy information, copy the songs onto the iPod actually had to sync with a particular computer. So you would have your main computer that had all your music on it, and your iPod would then be a reflection of whatever was on that computer. But if you took that iPod to another computer, it would erase whatever was on that iPod before it could actually go and put any information, sync any information from the other computer into the iPod. Now, there were, of course, programs that were then made to circumvent that so that you could actually get into the iPod itself and copy what was on there without needing to use the Apple Sync program. And when Sony and the other music manufacturers tried to stop these programs from working, people from being sold, the counter argument back was that people need a way to get into their iPods for maintenance purposes. They don't. Sometimes when if the iTunes was not working correctly or people were having trouble with their account, they still needed access to their music and to be able to copy it from, say, an old iPod that was hooked up to a computer that then crashed or the hard drive was broken. You couldn't easily recover the information off of only by, hooking the iPod back up or later the iPad, the iPhone to a system that would be able to then look into the device, copy that information, put it back on a new computer. Would you be able to save what was actually on that phone? And because they had tied the picture synchronization, so copying pictures was also something that you couldn't do unless you used the iTunes syncing program. The courts ruled that it was okay for these other iPod and later iPad and iPhone programs that would allow you to copy the information directly from those devices to another hard drive were allowed because people had other data that wasn't copyrighted material that they needed to be able to access and copy over to another computer. So that's kind of how B sort of 2B gets put into action, and that we've seen it used both for and against the DMCA because iPods were not in these copying programs that allow you to copy from an iPod directly onto another computer were allowed because it wasn't just being there to circumvent the copy protection and the syncing functions, but to allow people to copy things that were non-copyrighted and that were their own property. So C says marketed by that person or another acting in concert with that person, that the person's knowledge for use in circumventing that technological measure that effectively controls access to work protected under this title. As used in the subsection, it says to circumvent technological measure means to descramble a scrambled work, to decrypt an encrypted work, otherwise avoid, bypass, remove, deactivate, or impair a technological measure without the authority of a copyright, and a technological measure that effectively controls access to the work if the measure in the ordinary course of its operation requires the application of information or processes or treatment with the authority of the copyright owner to gain access to the work. So they do give an out for copyright owners to be able to give authority to have people access these items. It doesn't a lot of this has to do with just getting permission from the owner of whoever owns the copyright. So if a lot of folks tried to get access to it, a lot of folks that have committed copyright violations never even contacted copyright owners to see what their thought was on it and whether they wanted or whether they could allow that access. Sometimes they might have been able to do it if they sought permission, achieved it. So then the DMCA talks about additional violations, that no person shall manufacture, import, offer to the public, or otherwise traffic in any technology or service that is designed for the purpose of circumventing protection, has only limited commercial significant purpose to circumvent protection. And they really wanted to make sure that that people understood that when you had something that was based on trying to hack or break the copyright protection or whatever sort of device that was put in place to keep the items from being copied, that those were forbidden by the DMCA, and that there were significant penalties that were associated with that. And I do remember, in the 80s when people had, 8-bit computers, and there were a lot of copy programs that were out there, including stuff for, the Atari and the Apple computer. And one of them was this thing called the Happy Drive, which you would put into the Atari 800. It would allow you to make backups of your software, copy protected software, but they wouldn't run on another computer. And so you could make the backups, but the backups would only be associated with that Happy Drive. The only problem is that people figured out how to break the Happy Drive limitations. And so people were then able to use that Happy Drive to copy a bunch of different things and then move it over to other computers that way. So it's sometimes the device itself is not to blame, but it provides a way for people to then come up with a way to use it that does violate. So nothing in this section shall affect rights, remedies, limitations, or defenses of copyright infringement, including fair use under this title. Nothing in this section can diminish vicarious product liability for any product, service, component, or part thereof. Nothing in this section requires the design or designs of parts, components that are needed for managing any of these technological matters. But most important is number 4, which is that nothing in this section shall enlarge or diminish any rights of free speech or the press for activities using consumer electronics, communications, or computing products. And they also give an exception to libraries. So there was a lot of discussion during the creation of the DMCA, whether they should give these kind of exceptions. But the First Amendment would mandate that you cannot use the DMCA as a means to keep people from freely expressing themselves. So let's talk about some famous Digital Millennium Copyright Act cases, okay? Because then we can see how these cases, how this law, and it was a lot of law. I apologize for going through so much of it, but we can see now the structure, how these cases are being looked at, and that'll give you maybe an idea of how the law actually works. So one of the biggest cases when the DMCA first was enacted was to file suit against a company known as Napster. Now, Napster used what is known as peer-to-peer networking in a time where peer-to-peer networking didn't really exist. Now, peer-to-peer networking, to explain how that works, is that you don't have a file. Let's say you wanted to send a big file to somebody, or you wanted to share a file with somebody. You can use peer-to-peer networking to directly send information, large amounts of information, to other sources by using instead of a server, you use a network of smaller systems that all communicate through a particular piece of software. Now, in the case of Napster, Napster had its own software that you downloaded. There were other services such as LimeWire and I'm trying to remember the other, peer-to-peer sharing services, but LimeWire and Napster were the two biggest. And Napster itself was not running a server. Napster itself was not actually possessing any of the files that came through its network, through the software that it created. In other words, it was coming from one person's computer and going to another person's computer and bypassing a centralized server to be able to transfer the information. So people were able to use peer-to-peer networking to share files such as music. Okay, well, that was a big deal for Napster. Is that back in the day, emailing something to somebody, like say a song, if you had a digitized song, that was like a 3 meg file, and say a record album has 12 songs on it, so that's going to be 36 megs, and a lot of people didn't have file size in their emails to fit something that was that large. So peer-to-peer networking allowed people to transfer entire albums or later movies with bypassing the email server entirely. So the file size limit didn't really matter. And then the peer-to-peer networking got even more complicated, which is that it allowed people who had the same version of the same file to work together to make downloading faster. So in other words, you would be downloading part of a file from, say, the first half of it from one user, and you'd be then getting the middle of it from another user, then you get the very end from another user. depending on how fast their connections were, you could start doing it in a much quicker way and have a much greater selection of what you were finding what you were looking for using a peer-to-peer network than through a server-based system where what's on the server is what you get, versus a peer-to-peer network where you get to look at all the files that are on all the peers that are in the entire network, at least the files that the peers have chosen to share. Now, there were certainly viruses and malware that exploited this and would, go beyond what people wanted to share initially, to share everything in their hard drive too. So being part of a peer-to-peer network wasn't always the safest way to go if you wanted secure information. So really, Napster was file sharing before Dropbox and Google Drive ever really were in the business. It showed that there was a need for something to be done in that area. The technology rose up to meet a demand before a company could actually offer a service to do it. And it is interesting that there are no real limits on what Dropbox and Google Drive do as far as what you can send through it. And it's just as easy to send copyrighted material through Dropbox and Google Drive, but Napster, of course, was eventually shut down. It did basically make the policing of DMCA up to the corporations themselves. It does not. There is no real entity. I mean, the FBI is supposed to, and we used to run those videotapes at the beginning. They would have the FBI warning saying, copying this is crime and so forth. But the FBI really does not have the capacity to go after individuals or small cases. Only on maybe an international level can they really do anything about copyright violations. So they've made the DMCA up to the corporations themselves, and sometimes to the cable and broadband companies to limit the accounts of people who are DMCA violators. Napster still remains, but it's a shell of what it was. It doesn't do the same kind of music sharing service that it used to be. It's now more of just sort of a portal to purchase music. But peer-to-peer networking still exists. And in fact, it may be stronger than ever under a concept called the BitTorrent, which does all of these things that Napster does, but even more remotely, in the sense that there really is the peer-to-peer software is made by developers who really don't run much of a company. They don't make much money off of it. So there's not much economically to shut down by the makers of these different BitTorrent softwares. So they operate with a lot more anonymity. And then the power of computers now to copy things and the speed of the networks make copying material from the internet so much faster and so much more powerful than you were able to do years ago. And so the BitTorrent, as I said, works on that method of looking to other people throughout the entire BitTorrent network that have the same file that you're looking for. So for instance, say someone is looking for, a movie, or another piece of copyrighted material, a video game, for instance. You go to the BitTorrent site. Some of them were like Pirate Bay is a pretty good example of it. You would type in your search and you'd say, I want to download, say, Star Wars. I want to download, the latest Star Wars movie. Well, then you go to Pirate Bay. You would run your BitTorrent software in the background, and then you would get you would go on to Pirate Bay and you would type it, search for what you're looking for, and it would give you what's called leaders or sites that it would be what would connect you to other people who are on the same network, the BitTorrent network, that are sharing what you're trying to find. So, in other words, you would then get a list like of 100 different, you know, uh, 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 links that you could click on, all of which are Star Wars. Some of them are in HD, some of them are in single def, some are, you know, Korean subtitles, and you click on it, and it then uses BitTorrent to coordinate between you and the other people who are on this network to share all those files between each other. And you can use the power and the speed of the internet itself, plus the connections of these other people that are sharing the file, to download a movie in less time than it takes to watch it, which is pretty amazing. I mean, you can, you know, in certain circumstances, examples show that you can download a movie and, you know, with a fast internet service in maybe like 5 to 10 minutes. Same kind of thing, you know, that enables streaming to work. You can also use that to copy movies and download them, you know, to your hard drive. And that, of course, is a huge copyright violation and something that is, you know, it's a cat and mouse type of scenario where you have the companies trying to protect this and trying to go after violators, and violators coming up with new and different ways of technologies to circumvent it. It just continuously goes round and round and round. Early in the DMCA's history, you had the Motion Picture Association of America filed suit against Real Networks pertaining to its Real DVD software. This software enabled users to rip DVDs onto their hard drives for use without using the actual disc. They filed suit and won, saying the lawsuit was that the anti-piracy measures, such as the rip guard, were circumvented, the Arcos protection system they had. They also claimed that Real had broken their license agreement with the MPA's content scrambling system. So you're always going to, one of the big problems with copyright protection and having things that are protected is that it makes transferring these things, streaming them, being able to share them to the public so much more complicated. And so making people have to keep physical copies of movies and DVDs and music is kind of a thing of the past. It was such a different system when you had records and you had tapes. Being able to copy a record or a tape took as much time and effort as it did to listen to the actual album, and you could only do it one at a time for the most part. It was very hard to do multiple tapes. I mean, it could be done, but it took, you know, a lot of mechanisms to do it. So the ability to pirate something back in the day when it was just music and when it was just videotapes or laser discs was not a big deal because you just didn't have the technology to do it, and the ability to do it was so difficult. But as we've gotten into the DVD realm and also CDs, all of that music is digital and can then be copied onto a hard drive. And then once it's on a hard drive and it's off of the physical medium that it came on, you can do anything with it. You can, you know, email it or copy it or post it on a, you know, a server to be copied by multiple people or BitTorrented to literally the entire world. And so it's still a big problem, I think, for the Motion Picture Association. And even though they were able to put neural networks in its place, there's still a significant threat to the Motion Pictures Association by streaming. It both is important for the Motion Picture Association to be able to have streaming, because that's how people want to watch most of their movies these days, especially as we're still in the COVID crisis as it stands. Going to theaters is impossible. They're all closed. So streaming is the only way for them to get their product out. But on the other hand, once you get something streamed to you, and if you record it on your computer, it's very hard for them to control it, to make sure you don't take a copy of that and just put it on the internet for everyone to access. So then we see in another case, YouTube and its parent company, Google, which is now Alphabet, faced a lawsuit pertaining to the DMCA pressed in by Viacom. Viacom claimed that the site was guilty of massive intentional copyright infringement for having hosted 160,000 unauthorized clips of Viacom's program. It's gone up significantly since then. Google's defense is they cannot be held responsible for content uploaded by the users under the terms of the DMCA. And on March, a judge determined that Viacom had no punitive damage claim against YouTube or its parent company. But a motion for summary judgment was filed by Google and granted in 2010 on the grounds that the DMCA's Act safe harbor provisions shielded Google from Viacom's copyright infringement. And in 2012, an appeals court overturned part of this decision. Then in 2013, it was granted a summary judgment was granted in favor of YouTube, and an appeal was begun, but the parties settled in March 2014. So you can see that even from something that goes all the way back in 2008, it took 6 years for them to actually wind up settling it. And so we didn't really even get a full explanation as to where the law stands on whether what YouTube did was really a violation of the DMCA or not. It seems like the most likely case is that what Google was doing was under the Safe Harbor Act, and they weren't guilty of violating the DMCA. But because of the settlement, we'll never really know. But what we do know is if you've been on YouTube anytime and tried to upload something that has, say, a song in the background, and I myself have experienced this when trying to do a tribute video for a friend of mine's brother who unfortunately died. I used a Beatles song in the background of the video, and certainly I was not using this for profit. I was not using this as a way to disparage the Beatles or take credit for making this Beatles song. Just wanted it as a background to a video slideshow that I created, and that was considered a violation and not fair use of the Digital Millennium Copyright Act. And unfortunately, they leave the video up, but they mute the music. So it's sort of, you have a silent, unfortunately, just a silent, video up there. And you can say, well, there's public domain music, you can always just go with something that is not copyrighted. But it's hard when you're talking about musical tribute for somebody. You're trying to pick a song, one of their favorite songs, and you're trying to make something that has some artistic merit to it. You just don't want to pick any song for that. It's something that, matches a vision, matches what your idea is as far as what your video should be about. And granted, the owners of the song do have a right to control how their song is being used. They have a right to control how it's being applied. You don't want. We've certainly seen in recent times Donald Trump being told by a number of musical artists that they don't like him using their music for his rallies and entrances because, one, they don't believe in his politics, and two, they don't want people listening to that music thinking, oh wow, well, if this song is being played, if a Queen song is being played by Donald Trump, then Queen must be must support Donald Trump, or Michael Jackson must support Donald Trump. Or the use of their music for a lot of people is a testimonial or an endorsement, or at least that idea that a license was voluntarily granted to a particular subject that they didn't actually approve. So there is, a understand there is certainly some logic to saying that you can't just use any copyrighted material the way you feel like. But it also is tough when it means that, the limits of trying to use songs in an artistic way that don't take away from the profit of a particular group or creator is forbidden, at least on YouTube. Another case was that IO Group filed a complaint against the VO networks, alleging that the media company allowed the videos of the IO Group to be viewed more than 40,000 times between June 1st and the 22nd. Similarly, VO sought protection under the DMCA, saying that it was the users that uploaded it, and not the VO network. IO contended, however, that VO's conversion of uploaded videos to FLV format for online viewing placed the materials under their control. And this would preclude them from safe harbor under the DMCA. The judge, however, determined that VO was not responsible due to the fact they merely set up an automated system being misused by some users. Uploaded videos are not screened. As such, VO had no immediate control over the content uploaded. Therefore, they were granted protection under the terms of the DMCA. So what we see by the VO case is that there's sort of the don't ask, don't tell type mentality, or the I see nothing defense, where if you basically set up an automated system to handle the videos, and the less you can say you have actual knowledge of what is going on with the videos themselves, the more you're able to avoid violation of the DMCA. Now, Google and YouTube have sort of taken it under their wings to take a lot of control over the videos. So they're very much covered under the DMCA, and they can't really, because YouTube wants to be able to say that they, are family friendly. They want to be open to the mass amount of the public. They want to be able to sell advertising. They want to be able to have all those things that come with, being a massive media site and one of the most clicked on sites on the internet. So there's a compromise there. To have that much control, to have that much power that they have, then there's also regulations that they have to adhere to. You can't just claim the First Amendment. They have no control over what's on there, and that applying the DMCA to them would be unfair, because they YouTube is for sure under notice that its system is used for uploading copyrighted material and so forth. And if there wasn't some kind of limit, people would just probably go stream a particular video and then download it and put it directly on YouTube, and then people would just be watching the video a day later. If they took their camera or they took their phone to the movie theater and just set it up and started recording it, they could wind up having it on that movie on YouTube within, hours, and then no one would go watch the thing in the theater because they could see it all on YouTube. Of course, there are plenty of rogue sites that will show up when there's a big pay-per-view going on, and especially the international level of how YouTube works makes that a challenge. And you also see other services too, such as Pinterest, Snapchat, Instagram, also kicking in on the DMCA violations by offering links to other offshore sites that will then provide, the pay-per-view that you're trying to watch, or to try to take you to a movie or something like that, some other site that would normally be censored by YouTube or by other more reputable services that are under control of DMCA. There's plenty of rogue sites that exist that are not under the control of the DMCA, and they are, when they're shut down, new sites just pop right back up, which are called mirroring sites, that will go and provide the same service, but just in another location, in the Bahamas, somewhere else where you can't reach them. Autodesk filed a case, was sued by Timothy Werner in 2007, and he was seeking damages for Autodesk's abuse of the DMCA by putting takedown notices on his eBay auction. And he was selling used software that he purchased at a garage sale. Autodesk claimed he was in violation of the software license agreement, was dismissed. So selling something from a garage sale is something that you can. Now, let's talk a little bit about the penalty the DMCA provides. And so the DMCA allows registered copyright owners to file a lawsuit in a federal district court. Federal court has the power to grant injunctions against the defendant and pay up to $2,500 per violation, up to $25,000. Copyright violations, the DMCA face large fines. A defendant faces a fine up to $500,000 or up to 5 years in jail, both a fine and jail for first offense. Repeat offenders may be fined up to $1 million as long as 10 years in prison, for both fine and prison. Criminal violation of the DMCA occurs when the defendant willfully violated the law for commercial or personal financial gain, such as selling cracked copies of copyrighted software. Copyright violators of the DMCA face large fines and in prison. A defendant faces a fine up to a federal court can impound property it believes was used to violate the DMCA. If the defendant is found to have violated the DMCA, the court can order the destruction of the defendant's property and can order the destruction of the goods that were produced by those two. So is the DMCA successful? Well, on the left side, we have the pros, and on the right side, we have the cons. And I'm not going to say which one I feel. I mean, there's legitimate arguments to both, and so here's the basic discussion. So for pros, that it's been felt that the blogs and search engines and e-commerce sites, video and social networking portals are all thriving today thanks in large part to the notice and takedown regime ushered by the much maligned copyright overhaul. Based on firsthand experience, studios would not have embraced DVD technology, not as quickly as they would have, knowing that they were going to be protected. There's tremendous concern in releasing movies in this greatly improved format that could not be protected against duplication. So the fact that there was a least legal structure put in place for companies to deal with people that would violate the Copyright Act. Made the Motion Picture Association decide that DVDs and eventually streaming would be okay because of the benefit that it would have to the industry for consumers. And as I pointed out, if streaming wasn't available right now, it would be interesting to know how well Hollywood would be surviving. You know, I guess they could be selling DVDs, but those are always limited to the people that have DVD players, and that you have to get the actual DVDs to people physically. And with physical DVDs, you know, you have the vulnerability and difficulty of mailing them and so forth. And it doesn't give people that instantaneous sort of instant gratitude, immediate gratitude that they are looking for when they want to see a movie. They just go and they call their cable company, or they hit something in on their remote, and they're able to stream it, you know, within minutes. The other pro is that under the law, every 3 years, the Librarian of Congress revisits the anti-circumvention measures and carves out a specific exception. In the 10 years, though, that process is paved way for only a handful of exceptions, and then a lot of times they are meaningless. But the 3-year review period and the librarian review does give the DMCA a chance to reinvent itself and to try to be a more effective law. And there's very few laws that exist that have this sort of 3-year review process built into it. So even though it's imperfect, it has the ability to modify itself and to be reviewed on a regular basis. So it's trying to be an up-to-date law. It's trying to be a law that can be adaptable as technology moves forward. Then an exception adopted during the last review in 2006 granted mobile phone owners the right to circumvent technological locks on their phone. Doing that allowed users to switch phone carriers without buying a new phone. So that whole thing that people were locked into their cell phones, and that they'd have to throw their phone away and buy a new phone to get it to work with a new provider, was actually wasteful and ridiculous and didn't need to be done. And it allowed people to what's called jailbreak their phones or their iPads or what have you, which was proprietary to a particular company. Once the contract had been purchased and once the phone had been paid for, you could go and use it with another company. But there are cons about the DMCA. People have felt that the DMCA chills free expression in scientific research by putting the threat of use of copyright violations against people who are making a derivative of something that features elements of the copyrighted work, but not entirely. The DMCA jeopardizes fair use. I gave my example of trying to use the Beatles song for musical tribute as a situation that is a problem. The DMCA impedes competition and innovation by, of course, giving the copyright to the person that has it, that other people that are trying to compete, that person have to get permission or license the item. If it's overly enforced, if the copyright is allowed to be too expansive, and the court feels that anything that looks at all like it is a violation, then you can have a situation where people will just be too afraid to even make anything that looks similar to it because they're afraid of being sued. The DMCA interferes with computer intrusion laws that because of some of the DMCA provisions. They're afraid that, uh, you're not able to then copy stuff onto your computer, or that there are items that would be on your computer that you couldn't maintain because you don't have access to it because it's copy protected. You can't take something that you have and back it up. Let's say you bought a DVD and you want to make a copy of that DVD, so in case the DVD that you have gets scratched or broken, and you don't want to have to buy another one, you should be able to do that. But that's something that would be a violation of the Digital Millennium Copyright Act. So there is a lot of questions about that. And also, like for instance, a lot of people have those quote unquote commercial DVDs that they would say maybe take their home videos and they would convert them to a DVD that only plays on a DVD player. So it wasn't like an MPEG file or an API file, but more it had to be played in a commercial DVD player. Well, now most people don't have commercial DVD players, so they want to have that video on their computer, and having it on their computer means being able to decode that commercial DVD, turning it into a AVI file. But of course, if you can do that with a commercial DVD, you could do that to any movie and then turn it into an unprotected AVI or MPEG file. So that in itself is creating a lot of conflicts. And then the DRM and CDs being copy protected makes using them in other devices, on your phone, in your computer, much more burdensome, and people like to have freedom to be able to just move their music and use their music whenever they want. So in conclusion, technology is always going to be changing. So no matter what the copyright laws are for today, and this is why they did put the 3-year review rule built into it, is that technology will change the way that we do things. I mean, we've gone from records and tapes, obviously, to 8 tracks, to CDs, to DVDs, to MP3s, to streaming, and all of those offer different challenges as they stand. So the Digital Millennium Copyright Act is going to have to just continue to evolve along with it. The value of intellectual property changes as well. People are less upset now that their song being featured on YouTube than they did when it started. And a lot of bands have actually enjoyed the publicity that a site like YouTube will provide for them when people, click on their video and listen to it. There's got to be a balance between copyright protection to benefit innovation, but to keep from overreaching or stifling innovation. That is always going to be the biggest question for the DMCA. Whether they are giving enough copyright protection to benefit the people who came up with these ideas, and make sure that people are getting the value for what they do, but they don't want to have the copyright be so expansive that nobody can even think of anything possibly related to this, or that have anything that even looks remotely similar, because that would be stifling innovation. Fair use defense is always going to be the trickiest and most challenging part of deciding whether the DMCA is effective or not. And it's, again, a slippery, it's a very hard concept to define, and changes what things are considered educational, what things are considered critical, what things are considered parody or satire, what things will meet the fair use defense. Now, maybe they don't meet it now, but in the future, as people's morals change, or as history has made something, turned a thing that was maybe once proprietary into something educational, that's always going to be up to determination, and fair use is always going to be argued in the courts, probably now until we come up with some other way of protecting intellectual property. Courts will help, but it's always up to the owner to fight. The courts can help someone pursue a copyright case, but there is no entity that's out there now, again, like the FBI, that's going to go actively find people and bring them to justice. If the owners are not willing to fight for their copyrights, or that it's just too difficult to do, eventually that copyright will go away and it'll be considered part of the public sector. And then there's always going to be international complications. Other countries that don't honor the same copyrights, that aren't part of the WIPO treaty, will always be a place that these sort of things source from, and can always be a place to house illegal servers that have information on it that you don't want. And it's always going to be a cat and mouse situation. You're never going to quite be ahead of the hackers. The hackers will always be reacting to security technology and altering it so that they can get what they want out of a situation like that. So that's always going to be the question. And then what will future generations think and do? That's going to be one that I can't answer for you now. The whole idea of copyrights may change in 10 to 20 years or 30 years. My grandchildren may think about intellectual property in a very different way than we do right now. It's all going to be what technology does for them and how they manage it. So I don't have any answers to that, just more questions. And speaking of questions, if you have any questions, please contact me. Here's my contact information. I really appreciate you folks listening to today's lecture, and thank you so much.